Stay tuned for the next edition of Zoom Landlord-tenant Talk Radio. The opening topic today will be the requirements of a notice to pay rent or quit. Hello, everybody. Yes, another edition of Zoom Landlord-tenant Talk Radio. It is November 2nd, 2024. The song was Stuck on You by Lionel Richie. It was actually released in 1983, 41 years ago. Before I launch my opening topic of the day, I just want to remind everybody that we got an election coming up on Tuesday. And for the sanctity of our industry, housing providers, we must vote no on Proposition 33. No on Proposition 33, yes on Proposition 34, and no on Proposition 5. So please, if you haven't voted, please make sure that you vote. Bring all your family members with you and friends and anybody else you can think of. We must defeat this proposition. Okay, let's open it up to our topic of the day, and that is the legal requirements for a notice to pay rent or quit. What are the legal requirements? If you guys have any managers or agents that maintain your property, I would suggest that if they're not watching now, that they come back and watch this on YouTube, because it will be posted within about an hour or two after the show is over. And I do certainly highly recommend what you're about to learn. So, what is a notice to pay rent or quit? What is it used for? Well, obviously, it's used for a situation where your tenant is not paying rent. This is called a notice to pay rent or quit. It is not a notice to pay late charges. It's not a notice to pay refrigerator rent charges or parking space charges or security deposit. It is just for rent. If you add any other item into a notice to pay rent or quit, guess what? You are going to lose. That would be a defective notice. Okay, when can you serve a notice to pay rent or quit? Okay, so now we know what it's used for. The next thing is, when can you serve a notice to pay rent or quit? Well, everybody knows that there is a 3 or a 5-day grace period that is built into the law before you can demand the rent. And the answer to that is absolutely false. There is no time period, grace period, for a notice to pay rent or quit to be served. If rent is payable on the 1st, it's payable on the 1st and it's delinquent on the 2nd. There is no grace period. Even if you have a grace period in your rental agreement, all that means is that that's when the late charge kicks in. But it has nothing to do when your rent is delinquent. When your rent is delinquent, that's the day that you can serve a 3-day notice. So if rent's payable on the 1st, like it was yesterday, November 1st was a Friday, you could serve today a 3-day notice. However, of course, there has to be exceptions. If the due date falls on a Saturday, Sunday, or judicial holiday, then that means that the tenant's going to have through the next regular business day to pay, and you can't serve a 3-day notice to the following day. So, for example, if the 1st just happened to be today, the Saturday, the 1st of November, assuming it was, the tenant's rent is not due until Monday, the 3rd, which means you can't serve a 3-day notice until the 4th. So when serving notices, again, you can serve it one day after it's due, but if the due date falls on a Saturday, Sunday, or judicial holiday, you got to wait the following day for that rent to be due, and then the following day after that is when a notice can be served. Okay. So you serve a notice. It's a 3-day notice. When does the notice expire? Because you know that you do not have to accept rent from the tenant after the notice expires. And by the way, you don't have to accept a partial payment. So if the tenant is offering you a partial payment of rent, you can reject that, saying, I'm only taking the full amount of rent owed. Of course, if you did take a partial payment, you would have to serve a new 3-day notice. But when does a notice to pay rent expire? And most people say, well, it's a 3-day notice, 1, 2, 3. So after the third day, it is expired. Well, that's generally correct, except, of course, our politicians have always built into the law many exceptions. So when counting days on a 3-day notice, you exclude Saturdays, Sundays, and judicial holidays. So what does that mean? That means if I serve the notice today, November 2nd, that would be day zero. The day you serve it is day zero. And since Sunday, the following day, doesn't count, that means the tenant's going to have till Wednesday midnight to pay. So Monday would be day one, Tuesday would be day two, and Wednesday would be day three. So they'd have until midnight of the third day. Now, it doesn't matter what day you serve it, what time of the day. So, for example, if I serve it at Monday at 9 o'clock in the morning, they still have through, in this case, Thursday midnight to pay. So that's how you count days when you serve a 3-day notice. Because obviously, if you want to reject the tender, then you have to know, because if the tenant comes within the 3 days and pays you the full amount of rent, you're duty bound to accept it. Okay, how do you serve a 3-day notice? Can you just mail it? Can you email it? Can you send it by FedEx? Do you happen to have a carrier pigeon with you? And the answer, all those are incorrect. If you're going to serve a notice, you have to at first attempt to hand it to the tenant at the residence. If in fact he doesn't answer the door, technically, if you know where he works, you're supposed to try to serve it to him there. But if you don't know where it works, then you post one on the door for the world to see. Doesn't have to be in an envelope. And then you mail one by regular mail. So you knock on the door loudly. No one answers, even though you hear a bunch of people behind the door screaming and yelling and the TV on and the cars are parked in the driveway. But if they don't answer the door, post one on the door and mail it by regular mail. That's all you need to do. I know in my law firm, when the process servers serve notices, they also take a picture, and that's part of what we call the proof of service. You certainly can take a picture yourself. Everybody has a smartphone, so you can take a picture of it, and it'll just add for more credibility that you did post it in a conspicuous spot on the property. Okay. What are the state requirements for what has to be contained in a 3-day notice? Okay, so I'm going to pull one up here, but I want you to know everything I'm showing you today is on my website at evict123.com. All the forms, all the notices, everything we're going to post and explain today, those are all on my website so that you can grab all of these items, okay? Okay, I'm going to share my screen now, and we're going to share this, and should be popping up right now is my 3-day notice, which is on my website. So let's go over the legal requirements of a 3-day notice. You have to have on that 3-day notice the name of your tenants. So you can see I put that in as John and Mary Smith. I had to write the amount that was owed, which is $4,000. Now that has to be exact. If you are off even by a few dollars, you will lose your case. That's certainly true in rent-controlled areas, and quite frankly, what is not a rent-controlled area at this point in time. So you need to put in the exact amount of rent due. Now, if you're not sure, it's permissible to ask for less. So sometimes when you're dealing with a lot of figures, maybe wipe off $20 or $30 when you're dealing with a lot of partial payments and that type of stuff, just so that you're lower. You should also have the period for which the rent is due. In this case, we have it where the rent is $2,000 per month. They owe for 2 months, October 1st through November 30th. So on that basis, you'll see that I have put that period there. You also have to have the address where to pay the rent. So I've made up an address here, 1234 North Anywhere Street. You should date the notice. Now, this is very important, ladies and gentlemen. Payment is to be made to who? If it's an individual, then right there where it says ZZZ LLC, which is a limited liability company, and I write that's the landlord of the property. That's who you have in your rental agreement as the landlord. And it might be an LLC, it might be a corporation, or it might be an individual. Well, that name goes right there. Person made, the payment made to ZZZ LLC. Then, very important, person to pay. You do not write a company name there, as you can see. You write the name of maybe your manager or maybe yourself. So if the rental agreement has your name, James Jones, then where it says ZZZ, you're going to write James Jones. You're also going to write James Jones again. And I even have it here to try to force you that that's an individual name. If you have the name of a company as to who to pay the rent to, you will lose your case because you're not in compliance with statewide rent control or statewide requirements. You also have to have an address where to pay the rent. You can't put in, I'll pick it up on Tuesday. That doesn't work. An address where the tenant can go. So right here, this obviously is a manager on the property because I have to pay apartment number 1 in the same building. You can do a PO box. That's permissible. You can do a bank account where he's putting money directly into your bank account. If you do that, then you have to have the address of the bank, your account number, the times that the bank is opened, okay? And you have to have a bank which is in 5 miles of the subject property. If you really want to figure out how to do that, let's pretend it's Bank of America. Just to put into Google Bank of America and then use the zip code. In this example, it's 90024. And it'll show you the address of the bank that's closest. It'll also tell you the hours of the bank so that you can fill that in. Okay, so that's in terms of where to pay. It's also permissible to have a rent collection box. I have one of those on one of my properties where they can just put the money there and you're going to write rent collection box and the address of the property. Okay. You also have to have a phone number. If you don't have a phone number, then you will lose your case. It must have a phone number. The phone number I listed there happens to be my office phone number if everybody wants to call us. So we have a 800 number, which is 1-800-77-EVICT. Okay. There are local requirements, and I'm going to stop sharing the screen here. Actually, before I stop, you'll see here I have the number of bedrooms. Certain municipalities and counties require that you put in the amount of bedrooms, but I'll get to that in a minute. I'm going to stop sharing my screen now because it's time to go back to see what I look like. There are local requirements, and this is that not only do you have to match the state requirements, depending on where your jurisdiction is, you have to match the local requirements with regard to the requirements of that particular locality. So, for example, in the city of Los Angeles and unincorporated areas of LA County, they have something called the fair rental market value. Fair rental market value. So what is that? That means you can't serve a 3-day notice unless the total in your 3-day notice exceeds that fair rental market level, which is published by the Housing and Urban Development, and it comes out every August. So what is that, for example? Well, for a single, it's $1,856. That's where there's no bedrooms. So if you have a single that you're leasing out for $1,700, well, that's below the threshold, the 1856. So you're going to have to wait 2 months, ladies and gentlemen, before you can serve a 3-day notice. For a 1-bedroom, it's $2,081. For a 2-bedroom, it's $2,625. For a 3-bedroom, it's $3,335. And last but not least, for a 4-bedroom, it's $3,698. If your 3-day notice doesn't have that in the notice now this is only for the city of Los Angeles, and for unincorporated areas of LA County. If the amount in that 3-day notice doesn't exceed that fair market rental value, then you cannot serve the notice for those two locations. Okay, you'll have to wait till the following month. In those situations, I recommend two things. Number one, never take a partial payment, because then you'll still be below the threshold on the second month, possibly. And also make sure that when you're renting out a unit, that you rent it for much higher than whatever that fair market value is. You must do that, because otherwise you'll have to wait 2 months to serve a 3-day notice. So the city council and unincorporated areas of LA council, those county supervisors, they're trying to keep rents low. Well, just the opposite, Mr. Politicians, just the opposite, because all landlords are going to now rent units for more than the threshold, because otherwise you're going to have to wait. And I would, since it goes up every year, make it higher than that. Okay. Every landlord's doing it. So they've just by themselves have raised the rents for the unincorporated areas of LA County, and of course, for the city of Los Angeles. Also in the city of Los Angeles and unincorporated areas of LA County, you have to have the bedroom count so that they can easily tell whether you're below the threshold or not. And believe it or not, in unincorporated areas of LA County, you have to also tell the tenant what the fair rental market value is for that unit. That has to be contained in the notice. Okay. All right. Let's go to the city of Los Angeles and also unincorporated areas of LA County will also require, for example, that you post certain notices on the property before you serve that notice. These are tenant protection notices. I'm going to share my screen now and show you what one looks like. And this is just for the city of Los Angeles. As I look for my share button here, there we go. And this is number 3. Okay, so the city of Los Angeles, for every residential unit, every residential unit, I don't care how it's a single family home in Brentwood, you have to have this notice posted in a conspicuous spot. If your property is under RSO, the Rent Stabilization Ordinance, then you're going to have to post another. Now, these two forms for the city of Los Angeles are on my website, so you don't have to panic, and they're always up to date. So print out these forms and put it in a little piece of plastic and throw it by the mailboxes or any place that's conspicuous for the property. Again, even if it's a single family residence, the one that I have up now, which is not subject to RSO, you have to at least do this for every residential unit. The unincorporated areas of LA County has their own form. And again, that form is also on my website, evict123.com. Okay, so make sure that those notices are posted prior. And some municipalities like the city of Los Angeles, where you also have to register your unit, you have to send that copy of the registration certificate that you get every year, and it has the year on it. You have to send that by mail to each of your tenants, and you have to do that prior to serving a 3-day notice. Now, is LA the only, and unincorporated areas the only ones that have this? No, there are so many jurisdictions, which I'm pulling up right now, that have their own requirements. So let's go down the list here. Again, this particular notice with all these addresses, they're on my website too, so you don't have to panic or grab this. But if you go to my website, it's in the free form section where all I'm talking about, you'll even see this. So for example, in Culver City, if I'm going to serve a notice to pay rent or quit, after I serve that, within 5 days, I have to send a copy of that notice to pay rent or quit to the Culver City Housing Division, and there's their address on Culver Boulevard. And I have to do it with a proof of service, and I also have to do it by certified mail return receipt. If you don't do that, you've just lost your case with regard to the service of a 3-day notice. But it becomes more insidious. Let's pretend I'm not going for rent. I'm going for a notice to perform or quit because they brought in extra people. Well, in that situation, I have to serve a 10-day notice to perform or quit, not a 3. And then after that, and I also have to, of course, mail it to the city with a certified mail with a copy of the proof of service. And then even more, Once you serve that 10-day notice to perform or quit to get rid of these strangers, these extra people are there, then I have to serve a 3-day notice to quit. They design these rules for every landlord to lose their case without exception. So again, this is all on my forms. I've made it kind of easy. The addresses of all these places. I even have one here, Cudahy. Cudahy has one. Cudahy, ladies and gentlemen. It's 2 square blocks. What the hell do they need rent control for? But they have it. So these are all the jurisdictions. And please be sure that you follow this by just going. And of course, if you use our service, and of course we do serve the 3-day notice, you will be totally in compliance with the law. Okay, I think this is going to conclude my topic on everything you need to know about preparing and serving a notice to pay rent or quit. We are going to open it up to questions, and we know the rules. This broadcast is for informational purposes only. It's not a substitute for legal advice. If you do want to talk to me, it's simple. If you're on the Zoom meeting, just electronically raise your hand. You'll see that in the toolbar on the bottom. If you have a case with me, I am very happy, but we do not discuss specific cases. This is only for general questions of law. And last, please don't be shy. If you have a camera attached to your Zoom or YouTube meeting, turn it, or actually the Zoom meeting, please turn it on, because when you talk to me, we'd all like to see what you look like. And it makes it a little easier and more enjoyable for everybody. It's not mandatory, but if you can turn on your camera, I would appreciate that. And we are going to open it up to our legions of people in our Zoom meeting who want to talk to me. And we're going to open it up to a person who we all know, Jim Polina. How are you today?
Doing good, Dennis. Thanks for the talk. I appreciate it very much. General question regarding AB 1482. If I give a rent increase that's under the legal maximum, and then the tenant says, "Oh, I can't pay that. I have to give notice to vacate." Am I required under 1482 to pay relocation assistance in that situation?
Okay, for the audience, 1482, AB 1482 is the Tenant Protection Act, and that is the statewide rent control. The answer to your question is if you give a rent increase pursuant to that and the tenant refuses to pay it, there is no relocation. The tenant just has to either pay it or move.
Okay, that's it. Thanks, Dennis.
Hey, thank you. Let's move on to Bert. Bert, how are you today?
Hi, Dennis. How are you doing?
I
Thank
am
you.
good, thank you.
Thank you for taking the calls. As always, appreciate it. Two questions really about your opinion, really, as opposed to legal questions. One is one of my tenants in a townhome in Orange County, other than Santa Ana, was complaining that the heater didn't work, even though it was 105 degrees. So I replaced the heater because that's what the heater person said I had to do. And then they suddenly moved out anyway. And now I'm debating whether I should expand that to include central air conditioning. And just a question, do you generally find that that's a good thing to usually do for rents long term?
Well, I mean, it's more of a economic issue. Most apartments don't have, most older apartments don't have central air and heating. If you think if you're going to have to start replacing all these heaters in all your other units, maybe it makes sense to do so.
It's just a single standalone. So, okay.
Well, then it's just a matter of economics because you put in a new heater now. So, but
Yeah,
it's really what you think and what will the value of the rental go up as a result of that.
right. Okay. And then the second question, I live in a residential area in Orange County, other than Santa Ana, and the owner of a property across the street from me, I don't know where they live, but they rent it out to a group of people that are an active auto repair shop out of the garage, constantly cars, 15 cars all over. They're always working on cars. There's sounds coming out. And I know that the obvious would be to go to the city. I don't know if they would follow up, but that might create some antagonism between them. Do you have any suggestions on how that might be handled?
I think you gave the suggestion. I would definitely go to the city. If you're afraid of antagonism, then what that means is that that car repair shop will remain in your residential unit for the rest of your life. You can't be afraid to take legal action. You know, we
Okay.
see this with landlords who the tenant owes money, but they're threatening them. And my position with that is, if you're afraid to take legal action, then you might as well just get your deed out and deed him the place at that point and let him own the property. But no, you have to enforce your rights. And they don't necessarily, when you complain to the city attorney's office for that location, that they're going to tell who did it. They're just going to go out and inspect it themselves. I would call building and safety. They'll
Yeah.
go out, and there's never a retribution as to which neighbor told them.
Okay.
Thank you.
That's great. Thank you. Thank you, Dennis.
All right, you take care, Bert.
Thank you. You
Let's
too.
see here. Okay, we're going to move on to Tony C. How are you?
Thank you, Dennis. Dennis, I'm getting ready to hire your law firm to start an eviction.
Well, you'll be
Two
the
questions.
youngest person to hire my law firm.
Look,
I
she's
can tell you
that
right there. I mean, you're
this
amazing
is
that you're that age and you can own a
hey,
building already.
this is the only way I can do to make keep her quiet, you know. Dennis, so my first question is, when you hire your law firm, do you go with a checklist of must-have things before you start a eviction?
Well, what we do is we do have a generalized information sheet and a confirmation letter, which basically tells the client when we start a case as to what is required, and also we send them the facts as to all the facts that the client gave. So we're confirming those facts so that there wouldn't be like a typo or a misaddress.
That would be that's great. So my second question is, if you have a family member who helped you or you help a family member to manage a property, do you have to give that notice to the tenants, or just in my case, I have a family member who's helping me out, but it's not a management company, just a family member. Do you have to disclose that to the tenants?
Well, first of all, are the tenants paying their rent checks to this manager?
Yes.
Okay, so I would do a change. You don't have to do anything formal, but just do a change of ownership or management. The form is free. It's on my website in the free form section, and just say that in addition, maybe you're going to put both names, my name, and also we're going to have such and such also as an assistant manager, and you give both phone numbers.
Perfect. Thank you so much, Dennis.
Thank you, Tony. Appreciate that. And we are going to move on to Austin. How are you today, sir?
Oh, pretty good. How are you, Dennis?
I'm doing good, thank you.
All right. Well, thank you for another weekly edition of Landlord-Tenant Talk. Uh, a couple questions surrounding stipulated judgments. I had a non-paying tenant, and we reached a settlement. The tenant has agreed to vacate in about 2 weeks. So I'm wondering, during this 2 weeks, the tenant, in the stipulated judgment, it says any money left over from the security deposit will get applied to the total judgment. So first question is, after I watched your security deposit video, in this particular case with a stipulated judgment, do I have to offer that tenant an opportunity to do like a pre-move out inspection?
Generally not. If you've already filed the lawsuit, you don't have to do that. There's no requirement. And generally, when you do these stipulated judgments, the way we do it is we always check the box that says that the landlord does not have to account for the security deposit. But if you've done it that way, then yeah, you're going to, after the tenant vacates, you got 21 days to deduct that, to deduct whatever deductions are, and then send them that itemization within the 21 days. Presumably, the person owes a bunch of rent, so he's not going to get anything back.
Oh, right, right. It was kind of creative the way it was written. I was actually pretty satisfied with it. But okay, so then the next question is, during this time, am I allowed to show the property to future tenants? I know that's kind of a dumb thing to do because, the tenant may not actually vacate, but could I do that? Could I advertise it and show it during this time?
And the answer is absolutely. Under the Civil Code 1954, you're allowed to exhibit the dwelling to potential tenants, applicants. So on that basis, you could serve a 24-hour notice and then go in during normal business hours, Monday through Friday. But I'm also in agreement with you that I don't think it's a good idea. The place is going to look like garbage. So I would wait. You can just imagine the way these places look. So you want to make sure the tenant moves out. Then you can take care of all the damage and the cleaning and maybe paint, make it look as nice as it can be.
Yeah. Okay. And then just real quick, the total judgment is, I think about 8,000, and the tenant agreed to pay, $300 every other Friday, until it's paid off. I doubt the tenant will actually do that, but let's just say they do. Do I need to send them like monthly statements showing, hey, okay, 600 this month, less eight or 8,000 less 600 this month, 8,000 less 1,200 the next month, blah, blah, blah.
The answer is no, unless it was contained in that stipulated judgment. I mean, it's always a good idea to send them maybe monthly or every 6 months a update as to what's still owed, just as a common courtesy, but there's no legal requirement.
Okay. All right. Thank you, Dennis.
Thank you, sir. Okay, we're moving on. Hovik, how are you today?
Hello, Dennis. Doing well, thank you. Uh, Two quick questions. I'm preparing a 3-day notice to cure or quit for one of my tenants who broke kitchen cabinets and also brought in a dog. Can I also serve a 24-hour notice to enter simultaneously notifying that, okay, I'm going to come, let's say, serve it today. 3-day notice will expire Wednesday, so I can enter Thursday. Is that a good idea?
I don't have a problem with that. You can certainly do that. You can serve, it doesn't have to be exactly 24 hours. You could do it, for next Thursday, to go in there and check to see. I'd also put in there that you're also going to be maintaining the smoke detectors to make sure that they're operational. Because I'm not exactly sure that under Civil Code 1954, you have the right to go in there to check to see if the tenant corrected those items that you were demanding in your notice to perform or quit.
I see, understand. And then last portion, you mentioned earlier for the 3-day notice to pay, that I have to write not only the landlord name, like the entity, whether it's an LLC, but also the person to pay. Does the landlord's name, also the agent's name, go on the 3-day notice to cure quit, or is it just agent is enough?
No, it has nothing to do with agent, has nothing to do with the landlord. On a notice to perform or quit for most jurisdictions, you got to have the name of a witness who
Okay,
can testify that those items were broken, et cetera, and that there's a dog there. So that what goes into a notice to perform or quit is a witness's name, someone who can say, yeah, that dog is there, and yeah, those cabinets weren't broken when I gave it to him, but they're broken now.
I could put myself as a witness. Is that correct?
Absolutely.
Okay, thank you, Dennis.
Thank you, Hovik. So we have a lively bunch of group today. Let's move on to Ashok. How are you today, sir? Ashok. Okay, I think Ashok is asleep at the wheel. We're going to move on to Margaret O'Brien. How are you?
Um, I have two questions. I have
Oh,
section
all right, can you hear
8. Oh,
Hold on.
yeah.
Go ahead, Margaret. Ashok, I'll get to you after this. You're a little slow, but after this, I'll get back to you. Go ahead,
Okay.
Margaret.
I have a Section 8 tenant and I want to put in a 4% rent increase, and I cannot bring up the form of Hakla on my computer. Can I just send them one of either yours or AOA rent increase forms?
Okay, you're doing a rent increase form?
Yes, for February 1st, 2025, because with Hakla,
Uh,
it took me last year 5 months before I got it. 5 months.
Okay, so I'm a little confused. You're talking about a rent stabilization under the city of
Yes.
Los Angeles?
San Pedro, yes.
Okay, so which is under the city of Los
Yes.
Angeles.
Yes.
And do you have your rent registration certificate that you've received?
Oh, yes, yes, yes.
Okay, so I'm a little confused. You can do a 4% rent increase
Yes.
And if you haven't done one within the last year, you can do it right now with a 30-day notice. If in fact you have done it, then it's 1 year from when you last did it, which if you did it at February 1st, 2024, would be February 1st, 2025. You could serve that notice right now if you like.
Well, I'm trying to, but on Hakla, I used to see they had a form that you could fill out online, and it doesn't come up anymore. So my
Okay, so
question,
I see you're just talking about where do I get the
yes,
rent increase notice?
yes,
It doesn't have to be on that format. Anybody can do a rent increase notice, and I'm proud to tell you, I happen to have a rent increase notice on my website in the free form section, and I mean free form section. So just use mine.
okay. And then in the same building, rent control, I had a tenant whose mother moved in with her. And in February of this year, I gave him a 10%. So it was like, let's say, $1,000 plus 4% plus $100, 10%. So it's 1140. Now, do I give him a rent increase of the 1140?
That's
4%?
what the rent is. So you can go when you do the next rent increase, the
Yeah.
total rent now is 1140. The next increase will be 4%.
Okay. And let's say the mother moved.
Let me slow you down for the audience. If you're in the city of Los Angeles and they bring in an extra person, which is not a child that's coming into the unit, but an extra person, you have, as long as you serve a rent increase notice within 60 days of when you found out that that tenant moved in, that extra person moved in, you are allowed to raise the rent 10%. Now, by the way, when you did raise the rent 10% plus the 4%, a total of 14%, did you serve a 90-day notice?
No.
Okay, so technically your notice is defective. So hopefully none
But
of your tenants are listening to this
I
broadcast.
don't think they know.
Yeah, yeah. Unfortunately, that can come to bite you when you get to court, and someone's going to say that that's an illegal rent increase, that you didn't have the right to have that rent increase become effective that quickly. So I got to watch that. If you're serving a rent increase notice for 10% or less, it's a 30-day. More than 10%, it's a 90-day. And if you mail it, add 5 days to each of those time periods.
Mhm. And let's say the mother moves out, and then I have to reduce it by 10% again.
Good question. If the extra person moves out, LA City says you've got to reduce the rent. Again, we're talking about RSO properties, but
Yes.
you've got to reduce the rent, correct?
Yeah. And that would be, let's say the rent has gone up from $1,000 to now 1140. So I would have to reduce it by $110 or
Yeah.
140.
Yeah, you'd have to take that back. Yeah.
Okay.
All right.
All right.
Thank you.
Thank you very much.
Thank you, Margaret. Moving along to Roman, I'm going to ask you to unmute yourself.
Thank you, Dennis. I appreciate you opening this to so many landlords. I have two questions.
I think do you have some background noise, sir?
I shouldn't have.
Okay. Oh, I think I see it right here. I got it. Okay. Go ahead.
I have a tenant who is creating disturbance when he is intoxicated or under influence of drugs. Tenants are really kind of intimidated by him, and they want to protect themselves by recording what's happening on the property. And they ask me for permission to install cameras, like ring cameras or camera on their doors. Do they need to sign form allowing them to do that?
No, just if you don't have to. If they want to put a ring camera and you have no problem with that, then say yes, please do it, because this way you'll be able to prove the improper conduct by this one tenant.
Okay. Okay, thanks. Another question I have, the two forums that you have on your website that deal with renter protection, do they have to be posted on the property permanently or only prior to serving the 3-day notice?
And the answer is it's permanent.
Okay, got it.
Okay, permanent.
Okay, thank you.
All right, thank you. We're going to move on to Ashok. I'm going to ask you to unmute yourself.
Okay, can you hear me, please?
Yes, we got you.
Sorry, my camera is not working, so I won't be able to. Okay.
No problem.
Question is, we had a tenant in August. We started remediation. They had a mold, and got letter through attorney, tenant's attorney, to remediate. So anyway, it's a long story, but we started remediation process in August, and we've been last couple of months. I think we had to go through a couple of iterations. They remediated, and the test again came out positive, so they did it again. So second time they kind of ripped apart the apartment, all the cabinets and whatnot. So it was a major work. So we finally, just a few days ago, we finished everything except very minor things. So we asked the tenant, or through our resident manager, that she should plan on moving back in. But all of a sudden we got a letter.
Okay, well, I'm confused. The tenants aren't living there during this time period when you're doing the mold remediation?
No, we had her move out. We paid 1 week's even rent, $360 per day.
Okay, so I got that. So what's the question, those?
So when resident manager kind of prompted her that, hey, get ready to move in, any minor little things we can do when you're here. But I got a long 1.5-page letter from her describing all kinds of things that are wrong. And
okay, but my friend, we're going too long with this. What's your question to me?
She says she's moving out end of this month. You made us move out, and it's a construction eviction and this and that.
Constructive eviction. Yeah, but again, my friend, I'm going to last chance. You've got to ask me a question.
What is the purpose of her letter? Is she has something?
And the answer is so simple. And that is, I've got no clue. What you need to do, if you're getting letters from an attorney, ladies and gentlemen, you can't just sit there and call in a talk show and think that the great Wizard of Oz, Dennis Block, is going to be able to give you a responsible response to that letter. You're going to need to hire an attorney. We do that type of
respond, by the way.
Ashok, I'm going to close you out here. You've got to hire an attorney too. If you get letters from an attorney, you've got to nip this thing, because otherwise you're going to be facing some sort of a lawsuit that you know is coming at you. So again, don't be penny wise and pound foolish. You've got to have an attorney review that letter and do a response back. Otherwise, you're looking at a lawsuit. In any event, I'm going to say hello to Sonia. How are you?
Hi, Dennis. I'm doing good. Dennis, my question is we have tenants, and the lease agreement, there's a laundry area. It did not specify anything like hours to be used, but now we'd like to have hours to say like between 7 a.m. and 11 p.m. So can we do that, or do we have to serve some type of modification to the lease agreement on that? What would you recommend?
Is this an apartment house?
No, this is like main house and 3 units. Everything's
what city, please?
Glendale.
Okay, I don't see any issue to that. I just post a sign saying the laundry room hours are such and such, and then have the door locked, and that's it. I don't think you need to do anything. I don't see that as any kind of a taking away of services, so they can't use the laundry room at 2 a.m. in the morning. So just post it, and I think you're fine, Sonia.
Okay, thank you so much.
All right. Sam, how are you today?
Yes, Dennis, can you hear me?
Perfectly.
All right. Question here. Suppose that somebody allows a friend to move into their condominium unit, and then they want the person to leave. Is it a normal, they have to go through the unlawful detainer process? Suppose they don't have mail coming to the premises yet, but they wouldn't be able to necessarily ask the person to leave because the police say, well, she's saying she lives here. Verbally.
Okay, first of all, the person who allowed this person to move in, is that person the owner of the condo?
Correct.
So the owner of a condo lets a friend move in. Has that person been there longer than 30 days?
Yes.
Okay, then that person has established possessory rights, and it's under a concept called tenancy at will. It's, I believe, Civil Code Section 789, and we need to serve a special 30-day notice to vacate and proceed forward with an eviction. You just can't lock that tenant out or that occupant out. A lot of times that happens when a parent will allow a child to move into one of their apartments, or maybe you meet a girl at a bar and you put her up in another unit, and then you want her to go. Once they're there 30 days, they do have rights, and they're considered a tenant at will, and you have to go through a type of an eviction to evict them.
In other words, 29 days or less, you're good.
That is correct.
Interesting. Okay, but on midnight of the 30th day, or midnight of the 29th, midnight at 12:01 a.m., midnight going from day 29 to day 30, they establish a tenancy. They've created you created a tenancy
A
in there.
type of tenancy called a tenancy at will.
Cool. Thank you.
All right. Good question. Janice from New York, how are you?
Good, Dennis. How are you?
I am fine, thank you.
Question, if I wanted to take over management of my property from a property manager, besides using your change of management form, would I add to that all provisions of the lease remain in effect?
You don't have to. The lease is automatically the same lease. You're just saying that there's a change of ownership or management.
Okay,
And the
great.
form that I have on my website, it has every requirement under the law, so make sure you use that one.
So if I'm going to use like door loop for electronic payment and so on, they would be added to
Yeah, you
the.
could put that in that change of ownership / management, but you can't have electronic payment under California law as the only method of payment.
Oh, right. Yeah, they have the option of paying by check locally at
Yes.
the bank. Yeah. Okay. Thanks a lot.
Okay, Janice, how's the weather in New York?
It's chilly now. It's chilly, and everyone is bummed out because the Dodgers won. So
Oh, let me tell you something about everybody else in this room is so happy that
I know, I
that
know.
the Dodgers won that. What an amazing series. And you know what? Your boys blew it. You know
Yeah,
that. In that
yeah.
last game with those 5 unearned runs. Come on.
No, but I don't think they ever really had a chance, but they blew it big time. Yeah.
Yes. All right, thanks, Janice. Okay, let's go to Derek. I'm going to ask you to say hello. Mr. Derek.
Hi, good afternoon. How are you doing?
I am good, thank you, sir.
Thank you. So, real brief question here, kind of pursuant to what you were saying earlier. The situation I was talking about is an LA City single family residence, non-RSO, on the 60-day notice for no fault eviction. Does the landlord have to specify the number of rooms in that specific situation?
The number of bedrooms is only for notices to pay rent or quit. And
Okay, not
obviously,
for.
you have to have cause to evict even for a single family residence in the city of Los Angeles.
Okay, great. And real quick follow-up question. Can you speak at all to the recent LA City adjustments this week where they voted to increase the TANO defenses, particularly the treble defenses and the addition of attorney's fees on the harassment ordinance?
Don't start me up. That is
Sorry.
such a crock of bull. They have this anti-tenant harassment ordinance where if the landlord violates some of these provisions, that they can get sued. There's attorney's fees, etc. There were 14,000 complaints filed after this first Tenant Harassment Act was promulgated by the city of Los Angeles. 14,000. There were only 6 valid cases. Since the 6 valid cases, can you imagine the despair and the harm to all these innocent landlords that had to defend themselves out of these 14,000 cases? As the way the anti-harassment ordinance was written, only 6 out of 14,000. And just the amount of trouble that these landlords had to go through to prove that they didn't harass the tenant because merely they said, hey, can you pay me my damn rent? So what does the city council do? And quite frankly, they just need to be buried. And if anybody wants to take that and put that up on some billboard, what Dennis Block said, I'll say it again. They need to be buried because what did they do? They've now enhanced the Tenant Harassment Act and made it even more easy for tenants to sue landlords. So in the face of having absolutely no reason to have this ordinance in the first place, they've now decided to strengthen it. Well, I've got a suggestion for these people who call themselves city council for the city of Los Angeles. You need an anti-harassment for landlords. Landlords are the ones that are being harassed by tenants. It's not tenants harassing landlords. And I'm on the front lines every day seeing this garbage of what tenants do to landlords. And they should put some real teeth in it where they get fined and maybe even misdemeanor charges for the abuse that landlords serve, not tenants. Anyway, you got me on my soapbox, Derek, and thank you very much. Okay, we're going to move on to, let's see, let's move on to Lynette. How are you? Lynette, are you there? Okay, Lynette.
Okay.
There you
now?
go. I see.
Okay, I'm going to put you on to my friend Ron because he's the one who asked the question.
Very tricky. Lynette starts it and Ron finishes it. Hi, Ron.
Yeah.
Hi, Dennis. Thank you for opening up the floor to people and taking time to do this. My father passed away July of 2023 and has left the house in trust to his 4 children and 3 grandchildren. There's currently one of my sisters who's living at the house and has lived there. She moved in rent-free in 2018, has paid and is paying no utilities or rent. We'd like to start a process. We've been trying to assist her to find assisted living, but she has been stubborn and doesn't want to do it. Is she disabled? She may claim she is, but we just want to know what can we do to give her notice. We've tried to meet with her and she doesn't want to talk about it. She gets angry. So we at least want to start the process with a notice, not an eviction, but again, listening for your feedback. How do we put her on notice? That
So
you're not
first
living
of
here
all, this is a trust. Who is the trustee of the trust?
myself and a different sister, where there's co-trustees.
So a trustee of a trust controls the property, okay? You control it. So just like what I was talking to Sam about, this is a tenancy at will. And even though she's, quote, a beneficiary of the trust, she doesn't control the trust because you and a different sister are trustees. So in that situation, this is a pretty simple case. We would serve a special 30-day notice based on that theory, tenancy at will. And if the occupant is not out at the end of the 30 days, we have the right to force her out by filing an unlawful detainer action.
Okay, I had saw online something about a partition, a partition plan that if somebody's a beneficiary in a trust and going to inherit,
it's not. You don't need to do a partition plan because what you need to do is get your place back. So maybe you're thinking of marketing it and selling it, and that's up to the trustees. We know who the beneficiaries are; they're going to get their share. But as to who controls the show, it's the trustees. So you need to get her out so you can sell the property and then divvy it up between all the beneficiaries.
And in the notice that we would give her, we just sort of an eviction. What has to be in that notice?
Well, that's a special notice that my firm draws up. So if you want, you can call us. It's not a notice that I have on my website.
Okay. Can I ask you one last question?
Sure.
Are we able to charge her utilities even though she hasn't paid any since ever that she's lived there, whether my dad was alive or not?
I mean, I think you could bring forth a lawsuit that she has to contribute that to the utilities. I mean, I guess the trust is paying for the utilities. I guess you could bring for a contribution and maybe take it out of her share that she's ultimately going to get when you do sell the property.
That's what I wanted to give her notice that we're going to start to have her pay a portion, and if she won't pay it, that we will take it out of her share.
You're wasting your time with that. The reality is you can send that to her, but the reality is that you just need to get her off the property. It's as simple as that.
Okay. Thank you, Dennis.
All right. Thank you. We do that case all the time, by the way. Pauline, how are you today?
Good. Hi, Dennis. I want to ask you, have a condo, but I registered for RSO because like a long time ago, the city tell me you're under RSO. So that's why I have two units, but you know, they are separate. With
Okay, well,
like
let me slow you down for the audience.
mm-hmm.
If you have a condominium in the city of Los Angeles, that could be under the rent stabilization ordinance or not. It all depends when it was built. If the condominium was built prior to October 1st, 1978, if it was built prior to that, if you're going to rent out that condominium, you got to register the units. Now, you're not subjected to rent limitations because under the Costa-Hawkins Act, which we know will continue after the election, because you guys are going to vote no on Proposition 33, you do have the
So
right to raise the rent to whatever level. Continue though.
okay, so that means I can raise the rent to whatever, even though I registered for RSO.
Yes, a condominium has no rent limitations. Again, if you go
Okay, I
above
got it.
10%, it's a
Uh-huh.
95-day notice if you mail it.
Okay, now this unit, one of the unit, they have additional tenant move in, so I give them like 10% increase because she has been living there for more than
Now, is this a condominium or is it an apartment? What is it?
is it a condominium?
Okay, well, we don't have to, again, whether there's an extra tenant there or not, you have the right to raise the rent to whatever you like. So even if there wasn't an extra person there,
Okay,
there is no limitations.
but that means on February this year I raised the rent. Does that
You can
mean
raise the rent as much as you like, whenever you like. So if you raise the rent in February of 2024, right now, today, you can do another rent increase. You can keep doing rent increases every month if you like. Okay, there
oh,
are no rent limitations for a condominium, regardless of whether you're under the rent stabilization ordinance.
uh-huh.
That
But if
ordinance only states that you have to have good cause to evict.
okay, but how about if now he said, "Oh, I have my brother left." Then am I going to reduce the rent?
Pauline, please take the wax out of your ears. You can raise the rent to whatever you like, whether there's a stranger there or not. So you certainly don't have to lower the rent. Anyway,
Oh,
thank you very much. I'm moving on to Eric. Eric S.
Oh, hi, Dennis. How are you?
I am fine, thank you.
I have a situation. I made a very small mistake on one of my 3-day notice. I put, I don't know how it happened, but I accidentally put the wrong zip code where to pay the rent at. Do you think that I will have a problem with that if they bring that up?
Well, I think a judge would be correct in dismissing your case based on a wrong zip code or a wrong phone number. So
Oh, real? Oh,
if it
wow.
comes out, you could lose the case on that basis. Some judges might say it's kind of de minimis that the tenant was going to deliver it, so you wouldn't need a zip code. But if you do put a zip code and it's wrong, you could get your case dismissed.
It's almost like not having an address at all, right? Because it's the wrong.
It's
It's
exactly
the
right. We've lost a case when the landlord gave us the wrong phone number for the manager, and the tenant in court just dialed the number and let the judge hear that it was a disconnected number. So
Okay, and then could you remind us again, because I know Tuesday is very important, of how we should be voting on the different propositions?
the ones that well, I can tell you who to vote for president, but
Okay.
but I don't think I'll go there. But I will tell you that for Proposition 5, which deals with bonds, which means our property taxes go up, vote no. On Proposition 33, which deals with getting rid of Costa-Hawkins, which means that they could institute get away with vacancy decontrol they can get rid of, which means you'd be limited what you can raise your rents on for new tenants coming in. So that's a definite no. And Proposition 34 is a big yes to prevent these types of initiatives being drummed up by these charitable organizations.
Okay, thank you so much, Dennis, for the.
Okay, thank you. Dr. or DJ Jordan, how are you?
Hi, Dennis. I'm fine, thank you. I do have 3 questions for you today. Is that okay?
Sure, we're at the end,
Yeah,
and I'm going to take one more after you. I'm going to take Martin Adler, so you hang tight, Martin. But go ahead.
one question is, am I doing an illegal increase if my property non-RSO in Maywood City? Last March, I increased, according to the law, the 5% plus 8% something, to the maximum allowed last March. And so 5 months after that, I noticed the tenant has 3 dogs. So I allow him to have it, but we enter a pest agreement and I increased $50. I'm
Okay, let
thinking,
me slow you down there. Maywood has rent control. I'm not sure what the rate is. There's just too many municipalities. So I don't know whether that's a legal rent increase or not. You'd have to check with Maywood to see what the proper rent increase was. But I can tell you categorically, if you allow them to have dogs and the rental agreement says no dogs, but I'll let you have it and you're going to pay me an extra $50, that agreement is illegal under any rent control statute or under statewide rent control.
but if it's not rent control, is that because I have another property that's
Is
similar?
this a single family residence?
No, this is just a 5 units.
Okay, so you're under statewide rent control. Statewide rent control does not allow you to increase the rent over what statewide rent control says because of a dog. So you are under rent control, either Maywood rent control or statewide rent control, but you cannot increase that. What's the next question? Because I want to move
Oh,
along.
how about in Clements? Clements, similar situation. We increase pet rents, but
Clemens, is that a city?
Clement,
Oh, you mean Claremont?
yes.
Okay, so Claremont doesn't have any rent control, but you're under statewide rent control. So again, if you were doing something similar, you would be under the same situation.
So that
Okay, I'm going to move on because I want to get to the last caller here because we are past the hour. And I'm going to ask Martin as our last caller. Martin Adler, how are you?
I'm fine. And Dennis, thank you for the brilliant presentation you gave the spooky tenants. My question, I have wall heaters. I pay for the gas. Tenant wants to put a cell phone controlled thermostat on. I'm very concerned about taking responsibility for that. We hear stories of evildoers hacking into Ring cameras, etc. I'd like to do it to keep her happy, keep her there. Is there a way to draft a document that would keep me out of any liability if there's a problem?
I don't think so. I mean, there's all these controls that I think the Ring doorbell has one that controls the temperature, and you can do it on your cell phone. I don't really see a problem with that. I have heard that people have gotten hacked into it, but I think they've done a much better job. If she wants to put it on, I don't see a problem with that.
No, she wants me to put it on.
Well, then if she wants to pay for it, say okay, but otherwise, then I don't want to do that. I'm not going to give you that amenity for no charge.
Gotcha. All right, thanks. And again, great presentation on
Thank you
spooky
very
tenants.
much. Okay, we're going to call it a day here. I do appreciate everybody coming out and listening to this. You know, I'll do this next week. I'm going to ask everybody, if you're listening on YouTube, please, I'd ask you to subscribe to my channel. And because it does bring in more listeners, and that's the only reason why I'm doing this. And with that, sayonara, have a great weekend, and don't forget to vote.